The argument had already started before Judge Frank Caprio reached the bench. That almost never happens. In 30-plus years on the bench, in thousands of sessions across thousands of mornings, the simple ceremony of the judge's entrance has always been enough to organize a room. People rise, people settle, voices lower, the day begins. But that morning in Courtroom 8, two attorneys were already standing and already loud when the door opened, and the argument between them had the hot, pressurized quality of something that had not started in this room and was not going to end quietly. The bailiff had already moved one step closer to the bar. The court reporter had her fingers on her keys but was not typing yet, watching instead the way everyone in the gallery was watching, with the wide, still attention of people witnessing something that has crossed from professional disagreement into something rawer and more personal. The fluorescent light above the defense table buzzed at a frequency that seemed, in that suspended moment, unbearably loud. And then Judge Caprio walked in, and the room did not settle immediately, which told him everything he needed to know about how serious this had already become. If you have ever watched a room that was spinning find its axis the moment one person walks into it, stay with me, because that is exactly what is about to happen, and what follows is one of the most important things I have ever seen inside a courtroom. Drop a comment with the word order right now if you believe that justice has to apply to everyone in the room, not just the people standing in front of the bench. And subscribe, because Judge Caprio is about to show us what it looks like when the most powerful person in a room uses that power exactly the way it was meant to be used. The case itself was a civil harassment matter. The plaintiff was a woman named Teresa Van, 38, a medical billing specialist who sat at the far end of the front row with her hands folded and her eyes fixed on the middle distance with the focused stillness of someone managing a great deal of emotion through deliberate practiced containment. She wore a gray blazer over a white blouse, her dark hair pulled back. She had a thin folder on her lap. She had been waiting for this hearing for 4 months. She had told no one at work she was here because she was afraid of what they would think, which was itself a fact about her situation that said everything and had not yet been entered into any record. The defendant was her former supervisor, a man named Craig Ellison, 52, who sat at the defense table in a suit that was expensive and slightly too confident. The kind of suit that functions as an argument. He had an attorney. His attorney was the source of the noise. His name was Gerald Price, 60, silver-haired, the kind of lawyer who has practiced long enough to confuse experience with immunity. He stood at the defense table with the wide-planted stance of a man who does not expect to be told to sit down, and he was in the middle of a sentence directed at the plaintiff's attorney, a younger woman named Dana Reeves, 31, second year in her own practice, who was standing her ground at the plaintiff's table with a stillness that was not submission, but strategy, her chin level, her voice controlled, her eyes bright with the particular clarity that arrives when someone has been professionally disrespected one time too many. What Price had said, prior to the judge's entrance, had been heard by the clerk, by the court reporter, by the bailiff, and by every person in the first 3 rows of the gallery. He had told Dana Reeves, in reference to a procedural motion she had filed the previous week, that she should let the grown-ups handle the complicated parts and that her client might be better served by someone with a little more seasoning and a little less emotion. He had said it with the smooth, almost bored delivery of a man who has said variations of it many times and faced no consequences for any of them. That was about to change. Judge Caprio took his seat. He looked at both attorneys. He looked at them the way he looks at everything, completely, without rush, reading what is there rather than what was announced. He said very quietly, "Someone tell me what is happening in my courtroom." Dana Reeves spoke first because she had been waiting for someone with authority to ask. She recounted precisely and without embellishment what Price had said, the exact words, the tone, the context. She did not editorialize. She did not perform outrage. She stated the facts the way good lawyers state facts, which is with a clarity so clean it doesn't need decoration. When she finished, she sat down. Her hands were steady on the table. Gerald Price spread his hands with the magnanimous patience of a man preparing to explain himself to someone he considers his junior. "Your Honor, I was simply making a practical observation about the complexity of the—" "Mr. Price," Judge Caprio said. Same temperature as always, window pane glass. "I heard what you said. The court reporter heard it, the bailiff heard it, the gallery heard it." a pause that lasted exactly long enough. What I'd like to understand is whether you believe it was appropriate. Price's hand settled. I believe it was frank, Your Honor. Frank, the judge repeated. The word sat in the air between them like an object placed on a table. The courtroom went silent, not the ordinary procedural silence, but the breath-held, suspended silence of a room that understands it is about to witness something it will not forget. Teresa Van, the woman at the far end of the front row who had been staring at the middle distance since the session began, looked up at the bench for the first time. Dana Reeves did not move. Gerald Price had the expression of a man who has just realized, a half-second too late, that the ground beneath him is different from the ground he thought he was standing on. That's when everything changed, because Judge Caprio opened the plaintiff's file, and as he reviewed it, page by careful page, with the reading glasses that the whole room had learned to watch for, because what happens after he puts them on is always worth watching, something in his expression completed a calculation. He looked at the harassment complaint. He looked at the documentation Dana Reeves had compiled, emails, workplace incident reports, a formal HR complaint that had been received, logged, and then quietly closed without resolution 6 months earlier. He looked at a letter Teresa Van had written to her company's HR department, 6 pages of specific, dated, documented incidents, written with the careful precision of a woman who knew she was building a record because she knew she was not going to be believed without one. He looked at the date the HR case was closed. He looked at the name of the HR director who closed it. He looked at Gerald Price. Mr. Price, he said, your client is Craig Ellison. Is Mr. Ellison currently employed by the same company where he supervised Ms. Van? Price confirmed this. And the HR director who closed the internal complaint against your client, is that individual currently a personal friend of your client? The silence in the room became a different kind of silence. Price said he was not sure that was relevant. The judge noted for the record that it was extremely relevant because the documentation before him suggested that the formal internal process designed to protect Ms. Van had been closed not because the complaint lacked merit, but because the person who closed it had a documented personal relationship with the defendant, a relationship that appeared nowhere in the HR record but appeared very clearly in a social media post from 11 months ago in which both men were photographed at a private golf event, smiling. Dana Reeves had found that photograph. It was in her folder. She had not mentioned it yet because she had been waiting for the right moment, and the right moment had just arrived. She placed it on the clerk's table without a word. Craig Ellison, who had been sitting at the defense table with the practiced composure of a man who has been protected by institutions for a long time, looked at the photograph and then looked at his attorney with an expression that contained, for the first time that morning, something genuine, something small and sharp and unmistakably afraid. Price was on his feet with an objection that dissolved before it completed itself because Judge Caprio was already speaking, and when Judge Caprio speaks in that register, measured, irresistible, carrying the full weight of 3 decades of watching people try to use power to erase accountability, the room does not belong to anyone else. I want to address 2 things, he said. The first is what happened in this room before I entered. Mr. Price, you told opposing counsel, a licensed attorney, an officer of this court, a professional who has done her job with more dignity this morning than you have, that she should leave the complicated parts to the grown-ups. You said this in my courtroom, in front of her client, in front of a gallery of people who came here to watch the law operate with fairness. He paused. His voice did not rise. It never needs to rise to be devastating. That was not frank. It was contemptuous. It was unprofessional, and it will be reflected in this record. He looked at Price for a moment that was long enough to be felt across the room. You have practiced law long enough to know better. That is not a defense. That is an aggravation. Price sat down. For the first time all morning, he sat down without being asked. The second thing, the judge continued, turning now to the full weight of what the file contained, is what Ms. Van has been carrying for 4 months, while the process that was supposed to protect her was being managed by someone with a personal stake in protecting the man she was filing against. She wrote 6 pages. She documented everything. She did everything right. And she was failed, not by the law, but by the people who were supposed to apply it and chose instead to protect their friend. He looked briefly at Teresa Van. She was no longer looking at the middle distance. She was looking at him. Her eyes were bright, and her jaw was set, and she looked, for the first time since she had walked into this building 4 months ago, like someone who was being seen. "That matters," Caprio said simply. "It matters in this room, and it will matter in this record." The harassment injunction was granted. Craig Ellison was ordered to have no contact with Teresa Van in any professional or personal capacity. The HR closure was flagged for review by the State Labor Board, with the court's documentation forwarded directly. Gerald Price was issued a formal reprimand entered into the court record, with a copy sent to the State Bar's Professional Conduct Office. He was also ordered to apologize to Dana Reeves on the record in open court, which he did, briefly, stiffly, in the tone of a man performing a task he finds beneath him, but performing it nonetheless, because the judge had asked, and because the record was open, and because there was nothing left to do but comply. Dana Reeves accepted the apology with 2 words, and the level gaze of someone who didn't need it to feel vindicated, because the record had already done that. Teresa Van walked out of Courtroom 8 into a hallway full of afternoon light and called her sister from the top of the stairs and said very simply that it was done, that it had gone well, that she was okay. Her sister asked if she was sure. She said yes. She said it twice, and the second time she said it, she laughed. A real laugh, unguarded and sudden, the laugh of someone who has put down something heavy and is surprised by how light the air is without it. Gerald Price's reprimand was reviewed by the State Bar within 6 weeks. It was not his first. The Conduct Office opened a broader inquiry. Craig Ellison's company, upon receiving the Labor Board notification, retained outside HR counsel to review 11 additional complaints filed over the previous 8 years that had been closed under the same director. Several of those complaints were quietly reopened. Dana Reeves went back to her office that afternoon and sat at her desk for a few minutes without doing anything. Then she opened her laptop and started working on the next case. She had 4 clients. She was building something. She kept going. If this one landed hard, if you felt the weight of what Teresa Van carried, and the clarity of what the judge said, and the particular satisfaction of watching a room realign around what is actually right, leave a comment below with the word order and tell me about a time someone used their position to protect a person who deserved protecting. Share this with someone who needs to know that the law at its best is not about who is loudest or most connected or most expensive. It is about who walked in with the truth. And subscribe, because this courtroom keeps showing us week after week that dignity is not a courtesy, it is a requirement, and there is still in this world at least one bench where that is enforced.